My name is Ian Mann, and I am joined by my colleague here in Hong Kong, Dayton Riddle. Welcome, Dayton.
Ian, thanks for having me back. It feels like only yesterday I was here talking about Supreme Tycoon, but...
I don't know how we tricked you into coming back, but thank you very much for attending. You obviously enjoyed the first session immensely.
Of course.
So today, we're going to be talking about a very weird line of cases in the Cayman Islands, which I'll just call the sort of Emmadart point, which sort of flip-flops and seems to have settled for the moment, but watch this space. We're always looking for opportunities to change the law again. But it had quite serious consequences in a number of cases involving fairly substantial companies here in Asia. So, broadly, what is the Emmadart point, if I can put it that way?
Sure. I think at its core, simplest terms, it's whether or not the directors of the company have the right to bring a petition to wind up the company with or without shareholder approval. So the UK position back in 1979 with Emmadart said that, without a specified power in the Articles of Association, a company's directors cannot bring a winding up petition without shareholder resolution or shareholder approval.
But very old law, but that sort of rather sounds fair, doesn't it? Because as a subscriber to shares, as a shareholder, you don't expect the directors to be winding up the company anytime soon.
Well, yeah, I would agree with that, up until the extent that the company is insolvent. Because at that point, the actions of the directors should be to the creditors and not to the rights of the company as a shareholder. So once you become insolvent, then the company should move towards insolvency and winding up.
And of course, if I was a director, I'd obviously be terrified about some claim against me personally, because I don't want to be trading. There's a public policy issue, actually, as well as then one for personal liability. I don't want to be trading whilst the company's insolvent. But, why would shareholders ever resist such a proposition? I suppose they'd be saying, the company isn't insolvent, or arguing that.
Yeah, I would imagine that, or it could just be that there's other
like looking for a sweetener, essentially.
Yeah, effectively trying to get as much out of the action as possible.
And listen, you call it a sweetener when you act for shareholders, and you say, you're unfairly trying to extract value out of an insolvent company in a restructuring when you act for the company, don't you? It just depends where you are in the capital structure, I suppose. But why also complicated in Cayman? So, Emmadart, very old law, as you say, 1979, that was the English common law, now seems to be the law in Cayman, but it didn't sort of start off that way. Well, just talk me through what was the first case on this?
So the first case came out back in 1998. It was decided actually by Justice Smelly.
Okay, as he then was.
Yep.
Now the Chief Justice of the Cayman Islands.
Correct. Yeah. Where he decided he had determined that the Emmadart principles applied in that the company couldn't be wound up without shareholder approval. Now, if we fast forward to 2011, Justice Jones looked at the 2009 revision of the company's law and made the determination that the directors could wind up with or without any specific power. Now, this directly went against the ruling in Banco Economico, and it was interesting in the fact that Justice Jones made that determination that the law said that the directors had the absolute right to do this, despite the fact that Section 94 didn't change from the previous version of the law.
Well, let's look at this, because it was a sort of, how do I put this? A left field decision, wasn't it? Section 94, subsection 2 of the company's law just says it. It says quite clearly that the directors need an express provision in the Articles of Association in order to present that winding up petition. End of, right?
Yep.
And so how does Andrew Jones sort of reason around that? With difficulty.
Yes.
You can't justify it.
Yeah.
He's being pragmatic, essentially.
Yeah. Effectively, he's looking for a valid way to introduce a restructuring activity for, in particular, Cayman listed companies, who are then, because it makes it very difficult to seek to have a director be able to wind up a company if you're having to seek shareholder approval at an EGM of a listed company. So,
and actually, just to give people context, 70% of the companies listed on the Hong Kong Stock Exchange are offshore companies, either Cayman Islands or Bermuda. And in order to effect a restructuring, you often put that company into provisional liquidation. In order to do that, you need to present a petition as well, which obviously you're not going to pursue. You're just going to, through a summons, have that PL. And so, to be fair to Justice Jones, most people thought that was a very sensible decision as a matter of pragmatism. But then Justice Mangatal, when we get to the case of China Shanshui, and if we're talking Cantonese, it is pronounced Shanshui, not Mandarin, where they'd say Shanshui. But in China Shanshui, everything changes again. And how so, Dayton?
Well, actually, Mangatal takes a look at the literal reading of the actual statute and says that Section 94(2) actually applies to all companies. It doesn't just apply just to solvent companies. And therefore, she reverts back to Justice Smelly's interpretation of the statute, and the Emmadart then applies. As a result of that, basically, it means that all companies that were incorporated prior to March 1st of 2009 had to have shareholder approval in order to be wound up in the Cayman.
Wow.
And if they were after March 1st, 2009, they would have to have specified power in the Articles of Association in order to be able to be wound up by the directors.
I suppose you're going to tell me Harney's has a little cottage industry in suggesting to people that if it wants to make amendments to its monarchs, it better get on with it, right?
Exactly.
That must be right as a matter of a forensic decision, a lawful decision. Justice Mangatal must be absolutely right, but it was a terrible shame in the context of China Shanshui, of course, because an appointment of a PL would have imposed a moratorium, which would have stopped just all of the wasteful, countless number of lawsuits involved in that company, and might have rescued the company better, as it were. But what a dilemma! And so, is that the end of it? Can all of this flip-flopping, as it were, stop? And can we tell our listeners that it's all just Emmadart, essentially?
For now, we can. But I think it's important to note there was a novel workaround that's actually been utilized several times since that. So, and that goes into CHC Group Limited.
Oh yeah.
And CHC Group Limited, Justice McMillan gave the decision in which a creditor, a company actually sought out and found a friendly creditor, who then makes the petition to wind up the company. And upon doing so, the directors can then immediately respond by making a summons to appoint PLs.
Wow.
So effectively, it goes around. Yeah.
Is there anything wrong with that? Is that a wheeze? Or is that just absolutely fine? You find a creditor that you say, well, you've got the right, the locus standi, and the cause to pursue this petition. Please threaten to wind us up, and that gives us, because of Robert McMillan's decision, that gives us the ability then to appoint PLs where perhaps we couldn't had we initiated it ourselves. Is that all perfectly sensible? I don't know.
I don't know the answer to that question either, but I think that is a perfect justification as to why the Cayman Islands likely needs to look to amend the current version of the company's law.
Or at the very least, this needs to go to the Court of Appeal, doesn't it?
Yeah,
we need some clarity as to how all this is really going to work. I have a lot of sympathy for what I always call the Rika Gold point, which is a sort of late 19th century English decision, and that just says, well, listen, if you have no economic interest in the outcome of a winding up, i.e. you're a shareholder in an insolvent company, then we're not going to listen to you. Why should we? And Cayman law has always been very clear on that. And essentially, in China Milk, that's what Justice Jones was saying. He's saying, well, I'm not listening to these out-of-the-money shareholders. I just want to get on with the people that matter and the economic outcome.
Yep.
Yeah. Okay. Well, interesting times. Watch this space. Dayton, thank you very much for coming.
Yep. Thanks again for having me.